All rise and be silent. The Honorable Judges of the Intermediate Court of Appeal, Chief Judge Daniel W. Greer presiding. Oh yay, oh yay, oh yay. Silence is not commanded under penalty of fine or imprisonment by the Honorable Judges of the Intermediate Court of Appeals are now sitting. Let all persons having motions to make an appeals prosecute come forward and you shall be heard. God save the state of West Virginia and this honorable court. Please be seated.
Good morning, everyone. Council can approach for the first case, and I'll ask the clerk to call our first case at this time.
First on the Rule 20 docket, we have James Atkinson v. NCI Nursing Corps and MedTox Laboratories, Inc., 22 ICA 233, an appeal from the Circuit Court of Harrison County.
Okay, Council, if Council ready, you may proceed. Mr. Strange, you have 20 minutes, and you can reserve whatever time you choose for a rebuttal.
Thank you, Your Honor. May it please the court, again, my name is Jeff Strange. I represent.
Yeah.
I was going to ask a question.
Yes, please.
Thanks. My apologies,
That's
Justices.
fine. No problem.
Again, my name is Jeff Strange, and I am counsel for the petitioner, James Atkinson. And respectfully, I believe we are here on a fairly simple issue. The fact of the matter is that Mr. Atkinson's claim, and to backtrack just a hair, I believe the briefs do stand on their own. And so, I don't wish to repeat a lot of the information that is in those briefs. But Mr. Atkinson did not make a claim under the MPLA in his original complaint. And the facts of this matter do not fall under the MPLA. The issues that are claimed in the complaint and the problems that occurred are problems relevant or pursuant to the United States Department of Transportation regs, as well as the West Virginia Office of Minor Safety and Health and Training. And those are the regulations under which Mr. Atkinson brought his complaint. Under the MPLA or under West Virginia Code, Mr. Atkinson was not a patient, and he did not receive health care. He was randomly selected to undergo a urinalysis to test for banned substances that, again, are under the regulations of the United States Department of Transportation for minor safety. There was no health care relationship. I have admittedly racked my brain to try to figure out the most eloquent way that I could say this. But the fact of the matter is, if Mr. Atkinson had literally urinated blood into the sample that he provided that day, nothing would have happened. If that sample had screamed that Mr. Atkinson had cancer or had any other devastating disease, nothing would have happened, because there were 10 specific items that the lab was testing for. The lab tested for those items, and it was returned. There was absolutely no health care. And part of where this becomes an issue, and there is a case that's relevant to this, is if one looks at the mirror image or the opposite side of this matter. There's a case, which is the Gooch versus the West Virginia Department of Public Safety, which was the West Virginia Supreme Court, and it's 465 Southeast 2nd, 628, where a gentleman was arrested under belief or suspicion of a DUI. He had health issues, but he never asked for help. He did request to have a blood sample taken. He was taken to a hospital. They took a blood sample. He ended up dying a couple days later. He was found not to be intoxicated, was released, and then was driving home, came upon a separate car accident, was found to be in distress, was taken to the hospital, and died. His family sued under the MPLA, claiming that he should have been recognized as being in distress and treated medically. The finding was that is not the case, because that's not what he was taken to the hospital for. He was taken for blood testing to determine if he was driving under the influence, and he wasn't. This fact pattern for Mr. Atkinson is the same thing. It was a test under DOT regs to determine if he was using illicit substances or not, and there was absolutely no healthcare relationship. There was no medical provider involved. There is nothing here that rises to the level of making this healthcare. And under the case that I cited, the WVU Hospitals case, I think that ruling is prescient when it comes to this, in that just because there are factors that sound like or seem like healthcare, like in this case a urinalysis, it doesn't necessarily mean that it's healthcare. And in this case, that's exactly what it was. It was a test for very specific factors, and anything outside of those factors both wouldn't have been considered, and had it been found, would have been disregarded. And there was certainly no expectation or anything else or contractual obligation implied or expressed whereby Mr. Atkinson would have expected to be treated if something had been found. And so what I'm respectfully, and Mr. Atkinson is respectfully asking this court to find, is that the court's ruling was erroneous in that dismissing this case because it was not brought under the MPLA and there was not a letter of certification and the proper steps were not taken was erroneous, and it should be sent back to the court to be litigated under the complaint as filed, which claims that there were DOT regs that weren't followed and there were West Virginia mine safety regs that weren't followed, and for those reasons, the test was invalid and the lab was in the
Counsel,
wrong.
a couple quick questions.
Yes, sir.
You understand that how you choose to frame your complaint is not determinative of whether or not it is covered by the MPLA.
Yes, sir.
And I want to make sure we're clear. Your main argument seems to be that it's not health care and not a patient. Do you concede that this would qualify as a health care provider or facility?
In this instance, I wouldn't, Your Honor, and that would be based on the definition in 557B2G, where it talks about healthcare provider. I do not believe what is going on here falls within that definition.
Even if he was being tested for treatment purposes?
Now, if it was for treatment purposes, absolutely, Your Honor, it would be.
Then you're merging the two standards, the two elements.
Well, no, sir, I believe the distinction is valid based on the case law. In this case, because there is no treatment expectation. The only thing that's being done here is determining, are these present? And then we report that to the DOT as required to ensure minor safety. But there is no diagnosis, and I think it's important. I think the term, which I believe was in respondent's brief, stating that it's a diagnosis of what is in the urine sample, I think is overly generous, because it is frankly an assay. It is a test to see, are these things present, and that's as far as it goes.
Let me ask one other question.
Yes, sir.
Regardless of what this court decides, am I correct that you have the ability, even if we affirm the lower court, to, under the saving statute, to refile?
And yes, sir, I do believe that is the case. Yes. And,
Thank you.
And if I may just to add, the one thing that I do think is relevant is that understanding that the manner in which the complaint is filed doesn't limit the manner in which it's looked at. The fact of the matter is, with the simplicity of what is being asked and what is being looked at by that lab, again, there's no medical provider overseeing it. There is simply testing. And again, and that is why it does not fall within the definition of a healthcare provider in this instance.
A couple follow-up questions on a healthcare provider. When you look at 557B2G, which defines healthcare provider, basically, in pertinent part, healthcare provider means a person, partnership, corporation, professional limited liability company, healthcare facility, entity, or institution licensed or by or certified in this state or another state to provide healthcare or professional healthcare services. Now, whether or not you agree that healthcare was provided in this case,
Right.
I certainly don't think you dispute that this entity, which in your complaint you allege is a professional nursing management company, would not fall into that definition. I mean, can't we agree at least that they fall within that definition of healthcare provider?
Yes, Your Honor.
Okay.
And-
So the real issue is not whether they're a healthcare provider, but whether they provided healthcare in this case, right?
That's correct, Your Honor.
Okay.
I agree. And whether or not Mr. Atkinson was a patient.
Okay. And patient is a natural person who received or should have received health care. Again, kind of circular.
Right.
We got to figure out what health care means later on.
Sure.
But it says from a licensed health care provider. So we're saying that if there's health care, this is a health care provider under a contract, express or implied. Now, does that say the contract has to be with the patient?
And it does not, Your Honor.
Okay, so a contract with the employer would suffice to bring under the definition of patient if this is healthcare, right?
Right, precisely. Well, assuming that is the intent, that the contract means it could be with anybody. And that, I think, goes back to that same argument with the DUI, where in this case, the contract was through the mine for the sake of compliance with DOT regs and West Virginia mine safety regs, and was for the purpose of determining whether or not these specific items were in someone's urine. That's it. And that's again why that argument, I believe, there would be no health care, and that goes back.
Well, I understand your argument about health care. I'm just trying to see where there's a real dispute and whether what we can agree on. So, but I appreciate your argument.
Yes,
Let's talk about Gooch for a second. Would you agree that there's any kind of a distinction to be made from somebody that's basically under arrest? And I think the case says he was asked, you want a breathalyzer or a blood test? It's not like he was the one wanting to go to the hospital. It's you get A or B, which do you pick? And he picked B, so they drag him there. He's certainly not one. I mean, is that any different? Is that different from this case? We're certainly, it's important for his job and all that, but there's not a law enforcement officer with him in handcuffs, dragging him there, telling him he has to do that. There's some element of choice there. Does that offer any distinction at all to Gooch, in your opinion?
Well, the distinction to me is, I think Gooch is actually almost a more extreme situation. I mean, and I realize what it is with the facts, but to Mr. Atkinson, in there, Mr. Gooch was taken to Raleigh General Hospital, was in the hospital for a considerable amount of time, was face-to-face with multiple healthcare providers, and nobody recognized that the gentleman was in distress. And even with that, and then he clearly had issues, and once it was determined he was not intoxicated, that there was no obligation, which I think is reasonable, not that we're getting into that, but for the law enforcement officer, for the trooper, to say, wait a minute, something's wrong with this guy, I need to get him help. The trooper's job was to focus on making sure the highways were safe. He saw a gentleman he believed to be intoxicated. He did his job. When he clarified he wasn't, he released him. This is the same thing. The test is to determine whether or not the person has been using inappropriate substances in accordance with DOT and mine safety regs, just like the trooper's job was to enforce West Virginia highway safety laws, and that's it. If there had been anything more in that urine sample, nobody would have done anything about it. And now, admittedly, if Mr. Atkinson in this situation was visibly seemed altered, that would have been a whole different ball of wax. But out of respect for what you're saying or trying to stay online with that, Your Honor, I believe, yes, that is why Gooch is very relevant here, because the important takeaway from Gooch is the burden that claiming that someone like Mr. Gooch is a patient would put on the state police and on the hospitals that would administer the blood test would be the same burden that then could come on to the mine and the lab if they test this sample and then Mr. Atkinson were to turn around and say, well, I've got severe AIDS or I've got severe cancer and you missed it, and now you're liable under the MPLA because you blew that. That's not what their job was.
Let me ask you another question, change topics a little bit. And you've referenced the other regulations that were at issue here under DOT regs or West Virginia Miners Health and Safety. Are you arguing that even if something, and I understand you're not conceding this point, I'm not asking you to, but
No, sir.
If something were clearly health care, are you saying it doesn't fall under MPLA if there's some other regulations at play, such as DOT or West Virginia Miner Safety? I think the respondent in its brief cited an example of a truck driver or something that had to have a physical as required by various government agencies. Would something like a complete physical, if it's done pursuant to that, does that fall outside of the scope of MPLA because it's being done pursuant to these other regulations?
And without getting too deep into the weeds off the cuff, I would say no, Your Honor. That I think that would fall under the MPLA because at that point, if you're doing a full physical, to me, you're checking the entire person's health. You are looking into that individual as a as a patient, for lack of a better term, you were looking to see what is their health status. And that is not what this testing did. So yes, I believe that is a fair distinction, and I do believe that would fall under the MPLA. Okay, and then at this point, I have nothing further. Thank
Okay,
you.
we'll reserve the rest of your time for rebuttal if you
Yes,
choose
Your
to
Honor.
use it. Thank you. Mr. Taylor.
Good morning, Your Honors. Justin Taylor, Bailey and White in Charleston, on behalf of the respondent, NCI Nursing Corp. I think we've somewhat, with your questioning, somewhat narrowed down the issues, and like my brief goes through, there's nothing magical or special about my argument. I just applied the allegations and the assertions in the complaint and applied them to the definitions of healthcare, health care provider, and patient. And we've kind of already walked through healthcare provider and patient a little bit. And it seems like you guys want to narrow down on what is medical treatment or a medical diagnosis.
Before you do that, though, let me go back to the patient issue.
Okay?
Justice Cleckley's decision in Gooch relied heavily on Rand versus Miller. And in that case, it basically talked about a distinction of whether there is, in fact, a physician-patient relationship established. And under the facts of this case, explain to me what would justify the creation of such a relationship.
The definition is a natural person who receives health care, and we got to go back to healthcare definition in a little bit, from a licensed healthcare provider, which is NCI Nursing, or the nurse technician, under a contract express or implied. That's the definition we need to focus on under that statute.
Except in Rand versus Miller and really in Gooch, the focus was on whether or not there was a contract, express or implied, between the patient
Yeah.
and the physician, rather than some third party.
Well, we don't have a physician here. We have a nurse technician, nursing company that does the testing for this urinalysis. The contract would be, there's a contract between the coal company who employs the plaintiff and my entity to come and do the collection work for the urine specimens, okay? That's the contract. That contract flows to the employee plaintiff
And
for the benefit of everybody involved.
what's the basis of you saying that it flows to the employee?
Well, that's the whole point of, under the law and everything, you have, they're supposed to do random drug testing to have your minor certification, and that's what occurs. So there wasn't, the employee's not going to sign a contract with the entity, so the employer brings down a group of employees under the contract. The employee consented to the drug test. Maybe he has a contract with an employer, maybe documents, because we haven't dug into the facts of this case because there's no discovery, because this is on a motion to dismiss. He might have signed something saying, yeah, et cetera, I'm here, I consent to this drug test, this is my urine. So in my opinion, that contract has to flow, because the entity is not getting drug tested. The employee is getting drug tested. And that's the whole purpose of this contract, is to get their employees drug tested. So
How is that different than what happens when the police bring somebody to a hospital for a drug test?
well, a policeman is not a medical provider. That's the difference. Policeman is a
The policeman's
officer of the law.
in the same position as the employer would be, bringing a
No, the policeman is not the employer of that person he just arrested. That's a criminal issue. To bringing that person to the healthcare agency or wherever, the hospital, and do the drug test on a criminal issue, he is not in any type of relationship as an employer, as the employer is here, or as the drug testing company. That's contracting with an employer. There's no contract that existing in that Gooch case between anybody. He's just doing something he's required to under the law.
So you would distinguish cases in other jurisdictions, like the Clough-Lively case in Georgia, the federal Billingsley case, 2006, Alabama Federal Court, where they make a distinction between an occupational drug test and somebody that goes to a facility at the direction of a physician for a testing that might include a drug test.
Correct, but the Billingsley case clearly held that the testing and reporting of a urine specimen of an employee plaintiff constituted medical care under the Alabama Medical Liability Act. And that's what's happened here. We just, that's the exact same scenario. They did a urine specimen, a lawsuit was filed, and they said that urine specimen collection action fell under the Alabama Medical Liability Act. That's all I'm arguing.
Well, but they made a very clear, important distinction, that in that case, it was also being used for treatment.
And if we go back to the definition of healthcare, which Judge Greer wanted to focus on, if you look at that specific definition, treatment's only one little part of it. It's any act, service, or treatment provided under, pursuant to, or in furtherance of, and you skip all those other ones because there's a bunch of commas, medical diagnosis. A medical diagnosis is a positive or negative drug test. If you test positive for marijuana, cocaine, barbiturates, that's a diagnosis.
That, in the medical diagnosis they're referring to comes under 557B2E1, correct?
Correct.
But is there, as I read 557B2E1, there's two parts to it. It's either under a physician's plan of care, which we don't have here, I don't think we do, or a healthcare facility's plan of care, medical diagnosis or treatment. Do we have a healthcare facility involved here?
That's where I'm going to get involved with the commas. It's not a physician's plan of care, comma. It's not a healthcare facility's plan of care, comma. It's a medical diagnosis, which is, there's a comma, medical diagnosis or treatment. I think that's separate. So that's why it's any act, service, or treatment provided under, pursuant to, or in furtherance of a medical diagnosis. That's how I read that definition.
Well, and I understand that argument, I really
Right.
do, because reading through this, I've been struggling with commas myself. But one thing that troubles me about reading it that way, doesn't that make the or treatment repetitive? Because it starts off any act, service, or treatment. And if treatment was just general and not meant to relate to healthcare facilities plan, why do we repeat or treatment?
I don't have an answer for that, but let's go to the second definition.
Okay, let's do that.
I think I win that one, but even if I lose, I check the box for number 2. Any act, service, or treatment performed or furnished by any healthcare provider or person supervised by or acting under the direction of a healthcare provider or licensed professional. And according to the complaint allegations, we got a licensed technician, nursing person.
Let's assume that we've conceded that.
Let's
and
move through
on.
that. 2 are on behalf of a patient, so it's circular. We got to say this guy's a patient.
We understand the patient argument at least, though.
During the patient's medical care treatment, including but not limited to, move down to basic care. Now, I am arguing that we fit under we checked several boxes under that one, but this is basic care, and I went out of state for this one because there's really nothing in state in terms of case law. Ferguson versus City of Charleston, which is South Carolina, Fourth Circuit. The collection and testing of urine was conducted in the course of medical treatment to which appellants consented. So South Carolina, Fourth Circuit says that's medical treatment.
Is that cited in your brief?
Yes.
Okay, I'll get the second, thank you.
And in Yin versus California, Ninth Circuit, the giving of a urine sample is a normal, routine, expected part of a medical examination. So I'm calling that basic care also. And then the Billingsley case, which we've already talked about that. So when it comes down to the specific language of the statute, that's all we're working with now. NCI Nursing and its act and services that it performed to get a medical diagnosis, which ended up being a positive THC diagnosis during their urine analysis, falls under the West Virginia MPLA, and it's our argument that the lower court was correct in dismissing the case because they did not abide by the 30-day notice of claim.
Counsel, in Gooch, Justice Cluckley spent some time talking about and also, I guess, in Department of Corrections case 2023 about the legislative purpose and intent of the MPLA. And in some of these cases involving whether it's drug test by police or as an occupational, there's a focus on that particular issue. Can you explain to me why you think your position would be consistent with the legislative intent of the MPLA?
Because we meet all the definitions. And we've got this is, a person was getting medical, a function was done to get a medical diagnosis by a medical provider, and that's medical care. So I think that's the distinction than some criminal law enforcement agency in charge of what happened in the Gooch case. And the Supreme Court has also ruled in either Gray and the Blankenship cases, the litigants are encouraged and urged to err on the side of caution and comply with the requirements, even if there's any doubt exists. I think that's what I'm asking, and that's what the lower court ruled. The MPLA does apply. I don't have anything further unless you guys have any more questions. Thank you, Your Honor.
Thank you. You have 7 minutes should you choose to use them.
Thank you, Your Honor. If we go back to the definition of patient, and there are the two factors here that I think are important. It means a natural person who receives or should have received health care. And I think it goes back to the point that the justices have made that there is no health care. And these other out-of-state cases, in those situations, there was an expectation of health care. And so that is where here, Mr. Atkinson was not a patient, was never a patient, and there is no definition in the code of medical diagnosis. And so to try to claim that a urinalysis that is testing for 10 very specific items is a medical diagnosis is significantly overly broad. The fact of the matter is it is a test for very specific factors to meet DOT regulations. It is not health care. Mr. Atkinson never became a patient, and regardless of what or whom the contract is with, if we go back to Gooch, there had to have been a contract between the state and the hospital to pay for the cost of the blood test. And so if we're saying that contract, any contract related to the act is relevant, then it would go right back to that same thing. The state couldn't contract to have someone test people's blood if they're suspected of driving under the influence without risking liability under the MPLA unless there are cases wherein you can have a distinction and that just because something involves the body or bodily fluids or things like that, it doesn't necessarily mean that it's a medical malpractice issue. And in this case, the malpractice that occurred was failure to adhere to DOT and mine safety regs, and that is the issue at bar. And so Mr. Atkinson never became a patient. And then when we go, the last thing I want to address is going back to the definition of health care. I think it's really important not to gloss over, especially in 5572E2, the second paragraph, further down where it says that it is, acting under the direction of a healthcare provider or licensed professional for, to, or on behalf of a patient during the patient's medical care, treatment, or confinement. There was no medical care or treatment here. And then the same, we don't have a definition of basic care, but here again, based on the case law, looking at Gooch, looking at the WVU Hospitals case, there is no basic care that is going to be provided no matter what a person says pursuant to a DOT urine test for the sake of mine safety. And for those reasons, Mr. Atkinson never became a patient. This does not fall under the definition of health care, and so this matter should be remanded for further litigation under those.
Would you concede that your clients agreed that however we define the services that were offered by the defendant in this case, whether that's health care or not, leaving that aside, whatever they did, he agreed that they would provide those services to him, correct?
Well, and just to make, not trying to pick nits by any means, but as part of, I think, choosing to be a minor, he absolutely accepted and agreed to the fact that he would be randomly tested. His urine would be randomly tested for the sake of ensuring that he was complying with the DOT and West Virginia mine safety regs. So if I'm answering that correctly, and that's why I'm trying not to.
Well, I think partly, but I mean, I guess my point is, he didn't have to undergo this, right? I mean, he could have refused.
Sure, but then he would have not been able to work.
I understand
Yes, sir.
that.
Yeah.
But still, it was his choice to do that.
Correct.
And he agreed, and he knew that however we define what happened, that they were going to do it, and he agreed to let them do it.
Yes, sir. I agree.
Okay.
And the only thing I would throw out on that is in those 20 years of being in the mines prior to that, every time those tests were done, it was purely to test for presence of certain substances. There is never a time in all those 20 years that Mr. Atkinson worked for the mines that someone came and said, "Hey, we did your analysis, and this looks a little fishy. You should go see a doctor."
Yeah, I understand that. I think we're stuck with the question of whether what happened here constitutes health care.
Yes, sir. Agreed.
I think that when you boil it all down, that seems to be the basic question for this court.
Yes, sir. Agreed.
If it's not healthcare, how does count one stay?
And
What is the profession that you count one as a professional malpractice claim? What is the profession that the nursing company?
as a laboratory that is expected pursuant to its contract with the mine to properly comply with every DOT reg that's out there so that the tests that it administers are correctly administered. And
you have privity and standing to assert a professional claim against a third party? Is that what you're saying?
and I will be the first to admit that I may have chosen a term that invited a little more scrutiny than was intended, and I take responsibility for that. But I think what I was trying to get to is the fact that the lab had the responsibility, to make sure their people were properly trained. And so again, admittedly, Your Honor, if I should have picked a better word, I do take that responsibility. But that was what I was getting to. All right.
Okay, I think we understand your positions,
Yes,
and the case will be submitted.
Thank you all very much.
Thank you.
All right, remain standing while the judges leave the room. And be silent. This court is again in session. Please be seated.
I'll ask the clerk to call the next case, please.
First on the Rule 19 docket, we have West Virginia Department of Health and Human Resources, Office of Health Facility Licensure and Certification v. Heart to Heart Volunteers, Inc., doing business as Serenity Hills Life Center, number 22 ICA 277, an appeal from the West Virginia Department of Health and Human Resources Board of Review.
Okay, Ms. C, you may proceed, and you have 10 minutes, and you can reserve whatever time you would like.
All right. Well, good morning, Your Honors, and may it please the Court. I'm Lindsay C. here today on behalf of the Office of Health Facility Licensure and Certification. Now, in light of this Court's directive to focus exclusively on whether the office even has standing to be here, I'd like to start with where the parties agree. We're not contesting the general rule that agencies don't have freestanding authority to appeal from the internal review process of a vertical review. But the Mason case, where that general rule comes from, gives two exceptions to the general rule, and both of them apply here. The first is that there are two statutes that give authority for the office's appeal. And the second is that the relationship between the office, the Board of Review, and the department as a whole is very different from the sort of agency relationship that Mason was concerned about when it talked about that general agency case. So either of those are independent reasons for standing for this appeal. So let's look at the statutory authorization. There are two statutes here that both say the same thing. Any party adversely affected by a decision of the Board of Review is entitled to judicial review. The first statute is the APA. All parties agree that that governs here for these contested case proceedings. The second is the statute that sets out the exclusive remedy for judicial review of Board of Review and Bureau of Medical Services appeals. And that one I want to pause because there's been a change in the law here. Serenity Hills was right in their brief when they cite to West Virginia Code 9213. That was the version that was in effect at the time that this appeal was instituted last year. That was repealed this past May, and it was replaced with West Virginia Code 16122A, but the key language that we'll be talking about is the same in both versions of the statute. So it's in a different place, but the statute itself is the same. And that also says that any party adversely affected by a Board of Review decision can appeal. Any party, of course, is broad. It means any, not just some of the parties. And there's no question that the office wasn't a party below. It was designated as a respondent. It submitted proposed findings of fact, conclusions of law. It put on evidence. It engaged in cross-examination, all the things that parties and only parties can do. So the question is, if there's some kind of exception in either of these statutes that says parties doesn't actually mean what it says and says agencies can't be parties. We don't have that exception. We actually have the opposite. Let's start with the APA. If you go to subsection B, it talks about what happens after a petition is initiated. And then it says the petition has to be served on the agency and all other parties. It doesn't say the agency and the parties. When the legislature said the agency is one of the parties, right, the agency and other parties, and then one subsection up said that all parties can appeal, we have to assume the legislature knew what it was doing. The agency can't be a party in subsection B and not a party in subsection A. We can see the same thing in 9213. It's subsection C there that says any party can appeal a decision from the Board of Review. But subsection B actually says that when it comes to the Board of Review's appeal process, there only applicants and aid recipients are allowed to invoke the Board of Review. That's the subset that Serenity Hills wants this court to use to interpret party, right? Those who are adversely affected by the original lower board in the agency by, the office's decision. But the legislature knew how to say applicant or recipient. It did in subsection B. But when it came to who gets to go to court, it used the broader language of any party. So both of these statutes say that any party means exactly what it says. We were a party below. We get to appeal here. That's more than enough in terms of Mason. Remember that Mason emphasized that the APA didn't apply there, so it strongly applied the result would be different in a case like this where it does.
How do you distinguish the JH versus Board of Medicine case? I know a memorandum decision where under that where the APA also applied, the complainant was not allowed to appeal the decision to dismiss the complaint?
There's two distinctions to that, Your Honor. The first is that the complainant was just that, filed a complaint against a doctor, but it was the Board of Medicine who was the party there, because the statute says the Board of Medicine is the one who initiates and prosecutes that action. So the complainant wasn't actually a party in the way that OFLAC was a party here. And then the second distinction, if we look at the organic statute, that's West Virginia Code 3313, then it doesn't say any party like the two statutes we have here. It says any person who is adversely affected by a disciplinary decision has the right to appeal. And again, that's the doctor, not the complainant. So that case simply doesn't apply. This is actually more like the cases that are cited in footnote 1 of Mason, where the Supreme Court talked about what sort of statutes would be enough. It talks about the Workers' Comp Board statute, and that one talks about any party dissatisfied with the decision gets to appeal. And that was enough for the Supreme Court to say that the Workers' Comp Commission could in fact appeal a decision from the Workers' Comp Board of Appeal. So we're squarely in that zone. There's nothing unusual about this. The statute that Serenity Hills argues comes from the legislative rule that says that an owner of a behavioral health center can appeal. But it's perfectly consistent with the laws we've been talking about. To emphasize one party who can appeal doesn't erase anybody else's appellate rights. And I use that language deliberately, it's consistent with, because the court isn't reviewing the legislative rule in a vacuum. We have 3 different laws here. And in that case, the court tries to construe all the laws together and to give effect to all of them. So even if the court thinks there's some tension with that language of specifying owners, you need more than tension in order to set aside one of the laws. As the Supreme Court says in the Camden-Clark decision, syllabus points 8 and 9, you really need a reconcilable conflict between statutes to set aside one of them. We don't have that here. It's perfectly consistent, again, to say who can appeal without saying that nobody else is allowed to. And even if the court thinks that there is this sort of irreconcilable conflict, it's the legislative rule that would have to be the one to fall, not the other 2 statutes. Because agencies, when they engage in rulemaking, cannot exceed their statutes. We cited syllabus point 3 of the Rao decision, which says it's not a problem just when agencies exceed and try to expand their authority, but even when they try to implicitly limit their authority, that's not allowed either. So if there was a reading of the rule that said by saying that only owners could appeal, the agency can't, somehow limiting the authority that the legislature gave to the agency, that provision would need to fall, not the other 2 that we've been talking about. So
Let me ask you if you could discuss and make a distinction. In the Mason County case, it talked about the quality of reasonableness of the general rule. And since we can assume the final decision of an administrative tribunal reflects the particular agency's policy to permit it to be attacked in the courts by its own personnel in the absence of an express legislative authorization, would open the door to competing and antagonistic policies. Why, in our situation, do we not have that potential for the antagonistic policy?
Because of the way that the Board of Review operates, I think first the Mason decision treated that as a second exception that only comes into play if there isn't other statutes. So if the court agrees with the first part of the argument, it doesn't need to get here. But this would be an independent reason because we have a circumstance here where OFLAC and the Board of Review are actually on the same rung of the organizational chart. In Mason, the court was talking about a circumstance where there was vertical review within the agency, and it said it just wouldn't make sense to let lower level agency employees appeal from a decision that higher administrative officials had made. But that's not what's going on here. It's sideways review, if anything. It's not vertical. And when it comes to the secretary, remember, when there's a Board of Review case, the secretary does not have authority to set aside or reject that decision. The secretary does have that authority if the Board of Review isn't involved. So that would be the circumstance that's closer to Mason, right? When there's a recommendation from a hearing officer and the secretary says yes, no, or accept with changes. That's not what happens here. And in fact, by statute, the Board of Review cannot speak for the agency. If we go back to 9213, it says the Board of Review must provide impartial review. So the Board of Review has to treat the agency just like the other parties before it. So Mason was concerned about the idea of having competing agency policies. But here we have a circumstance where by statute, we don't have the Board of Review speaking for agency policy. It has to be impartial between the actors before it. And then the last thing I'd say on that is even though, yes, the Office of the Inspector General is organized under the Secretary, by statute, nobody, including the Secretary, secretary is able to interfere with those functions. So what we have here is the OIG, and with respect, the Board of Review, who is reporting what it's doing to the secretary, but the secretary can't second guess that or ask it to change it in any way.
You've used 8 minutes if you want to reserve some of your time.
I think the last thing that I would say, because I think it's helpful in terms of this is not an odd situation, is just a little bit of historical context. The Board of Review process was not what was happening here until the last few years. Until very recently, we did have a process where it was the recommendation that went to the secretary. So in that case, when the secretary is giving final approval to all decisions, of course, we wouldn't be seeing appeals. This is very new here. So this is not a circumstance where the fact that the court has not seen these sort of appeals before should give it any reason not to follow the law as it's written.
Thank you.
May it please the court, my name is Bob Caulfield with the law firm of Flaherty, Sensabaugh, Bonasso, and I represent Heart to Heart Volunteers, Inc., DBA, Serenity Hills Life Center, the respondent in this matter. Serenity Hills is a 72-bed licensed behavioral health center located in Wheeling, providing inpatient, outpatient drug and alcohol rehab services to women suffering from substance abuse disorders. As has been indicated, West Virginia Department of Health and Human Resources through OFLAC licenses behavioral health centers under 2791 and the specific regulations that govern behavioral health centers, CSR 64111. My client initially obtained a license back in 2019. They were up for a renewal license. That renewal license was not granted after a survey that occurred and the facility was shut down and because the renewal was not, it was denied, and also a $10,000 civil money penalty was issued. That went up on appeal through the licensure rule for behavioral health centers to the Board of Review. Judge Bishop, on behalf of the Board of Review, reversed both of those decisions, and that brings us to today. As indicated, the court has only wanted to hear the question of standing. As Judge Scarr pointed out, the facts in this case are not where an outside independent tribunal questioned OFLAC's decisions to not renew my client's behavioral health license. Rather, the Board of Review, DHHR's own administrative tribunal, and Dave Bishop, DHHR's Board of Review designated hearing officer, concluded that OFLAC's actions were unsupported and erroneous. Respectfully, DHHR should stand by its own tribunal's decision. Here we're confronted with the department appealing a decision of its own tribunal. The stance defies logic and wastes judicial resources. The department, in essence, is seeking this court's intervention to overturn the judgment of its own administrative process. A fundamental principle of administrative law is that a final decision by an agency tribunal must be respected and adhered to by that agency itself. Here, the Board of Review, the very entity designated by DHHR and the Secretary to render a final decision, spoke. To have standing to appeal, a party has to be aggrieved of that decision below. In this case, we believe that Rule 31 applies. 31A clearly outlines the circumstances under which an appeal can be dismissed. The department, as established, the department, OFLAC, lacks the authority and standing to appeal the Board of Review's decision. Therefore, there's no appealable decision. The department lacks standing. Under the Paul B. v. Hill case in 1997, standing is an element of jurisdiction over the subject matter. Absent any appealable order and standing, this court lacks jurisdiction to entertain the appeal. We heard about the Paul v. or the Miss C. discussed the Mason case. She started at the very top with the Administrative Procedures Act as it relates to that particular case, and that can be distinguished. That case stands for the principle that an administrative agency, absent clear statutory authority, cannot seek judicial review of a ruling rendered within its administrative appellate hierarchy. Mason was different. Mason involved a county school board where a principal was discharged or dismissed by the county board. He appealed to the superintendent, which was a separate agency. That was reversed, and the courts found that there was a distinction between those. There was enough autonomy. We do not have that situation here. To understand DHHR, the secretary sits at the very top. Underneath that, we have the various bureaus, Bureau of Medical Services, Bureau of Behavioral Health. Separate from that, we have the Office of Inspector General. Underneath the Office of Inspector General, we have both OFLAC, the licensure body, and the Board of Review. This is not some vertical up change. These are all one entity under DHHR. The licensure rule, and again, we start at the Administrative Procedures Act at the very top, but down below is really the authority for DHHR to govern behavioral health center licensures and issue those. Under 2791, it sets forth the department's authority to issue behavioral health licenses. As a result of that, the licensure rule itself was developed. That's the behavioral health licensure rule under 6411. This includes all the requirements that behavioral health centers have to abide by to maintain their to get a license, maintain a license, and have a license renewal. Included within that section are the appellate grounds. And that specific rule says any owner of a behavioral health center who disagrees with a final administrative decision gets to appeal the decision. That's the situation that arose here. And OFLAC and DHHR should not be entitled to appeal the decision of their own administrative body who made that decision. Taking a practical approach to this from the standpoint of just looking at Judge Bishop's decision. The final pages of Judge Bishop's decision is titled Appellant's Recourse to Administrative Hearing Decisions. It's a standard form. It's the IGBR 46 form that's attached. It's a notification provided by the Board of Review. That notification was directed to my client, Serenity Hills, not OFLAC. It sets forth the appeal rights by Serenity Hills. Judge Bishop's letter to Serenity Hills did not include, it CC'd counsel for DHHR, but it states, you will find attached the explanation of possible actions you may take if you, Serenity Hills, disagree with the decisions reached in this matter. Counsel for OFLAC, again, was merely CC'd on this decision. The point on, again, and I'll go back to kind of statutory construction issues just for the court's understanding of the canons of construction. 6411, which is the behavioral health license, controls over the APA items that are there. That specifically states that a behavioral health center can appeal. DHHR actually has its own separate regulations that set out the rules for hearings under the APA. Under that separate set of regulations, the secretary or the Board of Review can issue decisions. If anybody else within DHHR, any other hearing officer is appointed, that individual, that decision or those findings of fact and conclusions of law go up to the secretary for final approval or non-approval. However, if the hearing officer is actually the secretary or the Board of Review, that decision stands. All appeals from those final orders shall be taken up by the APA. Again, we don't believe the APA applies here because there's specific statutory authority under the behavioral health licensure rule related to licensure. I'll end with just from the standpoint of the public policy side of this. We want assurances that coming out of the department that a decision made by the department, and again, we have the secretary who appoints the Office of Inspector General. The Office of Inspector General appoints the Board of Review and those hearing officers underneath that. The department cites in the petition the precedent for related to it, whether they cite no precedent of any Board of Review decisions that have been appealed by the department on an OFLAC matter. In fact, we could find no decisions along those lines. I think the reason for that is they do not have a right to appeal. In this particular case, they felt aggrieved and felt that they wanted to appeal. The other issue, at least from a public policy standpoint, is the chilling effect this may have on the Board of Review hearing officers. If the own department, whether it be OFLAC, whether it be the secretary, whether it be the Bureau of Behavioral Health or the Bureau of Medical Services, has the ability to appeal a Board of Review decision, we believe that that will have a chilling effect on the Board of Review. What's the purpose of the Board of Review if that's allowed to occur?
Why wouldn't that just the opposite be true? I'm not really following your logic on that policy question. If I'm a administrative, well, I'm a board of review, and I make a decision against the department, they can appeal. So I'm less likely to favor the department because they have an opportunity to get an independent judicial review. I don't really understand that. I think it cuts both ways. I really don't think it cuts necessarily fully the way you're arguing it.
And remember, the Board of Review covers all types of hearings for Medicaid benefits. So again, the department, I think, has given that authority over to the Board of Review. Under the Board of Review's own mission, and again, this is the Board of Review's statement, is to preserve the integrity of the department programs by providing due process to appellants through impartial hearings and timely decisions. We believe that it's set up so that that is a final decision maker with all types of decisions that DHHR has to make. Not just licensure issues here, but these are individuals who come before this court or have to come before this court for Medicaid benefits and for other types of issues. So again, I think that authority was given to the Board of Review. Again, remember, the secretary can make their own decisions. It can either be the secretary who makes a decision or it can be the Board of Review from that appellate standpoint. In conclusion, Serenity Hills seeks justice not just for itself, but for the people that it serves. We respectfully urge the court to dismiss the department's petition. The department and OFLAC do not have standing to appeal the final administrative decision of the Board of Review. The DHHR's own administrative body tasked with that function. This court should enter a memorandum decision dismissing petitioner's appeal.
Thank you, Ms. C. You have 2 minutes.
Thank you, Your Honors. Starting with the statutory point, what we didn't hear was any explanation for why any party doesn't mean exactly what it says in both of those statutes. We also didn't hear how the legislative rule that talks about an owner appealing is inconsistent with those broader statutes, which again is the standard this court would be applying.
We did hear an argument about why the APA doesn't apply. Could you respond to that?
Certainly, what we heard was the argument that in Mason the APA didn't apply, so I think that actually makes this case stronger because that was the first thing that the Mason court did.
But counsel discussed that it didn't apply in this case because of the specific rule of the agency.
Yes, Your Honor, that is just false as a matter of statutory interpretation because the APA does apply to these contested cases. That's what the legislature has said in the particular statute for the Board of Review. It refers to the processes under the APA. When it comes to the legislative rules, those deal with the specific processes for contested hearings in this context of appeals of behavioral licensing centers. And again, all we have there is the idea that an owner can appeal. That's not inconsistent with the statutes, including the APA, that say any party can appeal. So there's nothing in that rule that says the APA doesn't apply, and in fact it couldn't because the legislature has said that it does.
Wouldn't you expect that they would have added the additional language and would not have limited it to the owner if that was their intent?
No, Your Honor, and here's why. Because when that rule was written, it was a situation when we had sort of the more ordinary agency proceeding, when there was a hearing officer who made a recommendation that went up to the secretary, and then the secretary could accept it, reject it, or modify it. When the rule was written, it was reflecting the reality of who was actually appealing. It just didn't make sense. The secretary would appeal from a decision that he or she wrote. But later we've had a process change where since the Board of Review was added in just the past several several years. So it made sense that when it was written, it was reflecting what occurred at that time. But again, what we would have to have here is not just would it have been better to write the rule in another way, but is it inconsistent with the statutes that the legislature itself wrote? There are two separate statutes that say any party can appeal. The legislative rule is fully consistent with those. And there's no argument in terms of how this agency operates that would suggest that we should depart from that general rule of what the legislature wrote. Here, the department isn't appealing its decision from its own tribunal any more than the Commissioner of Workers' Compensation is appealing from its own tribunal from the Board of Review. Or for that matter, it's the same thing that happens every time Department of Revenue challenges decisions that come out of OTAW, the Office of Tax Appeals. That's lodged within the Department of Revenue, but there are appeals that can and do happen all the time by Revenue. So when we have a review board that is taking this quasi-independent role, and again, remember, we didn't hear any response to the statutes that say the Board of Review has to be impartial. This is not a circumstance where we expect the Board of Review is reflecting agency policy.
Thank you. I think we understand your positions, and the case will be submitted.
Thank you, Your Honor.
Thank you very much. We'll take a short recess.
All rise and reconvene while the judges leave the room. Be silent. This court is again in session. Please be seated.
Good morning again, and I'll ask our deputy clerk to call our next case.
The next case on the Rule 19 docket is Ronald Hardy, Ralph Manuel, Edgel Dudleson, Ricky Miller, James Cruey, Mark Scott, and Gary Scott v. 3M Company, Mine Safety Appliances Company, LLC, American Optical Corporation, Cabot CSC Corporation, Cabot Corporation, Eastern States Mine Supply Company, and Raleigh Mine and Industrial Supply, case number 22 ICA 123, an appeal from the Circuit Court of McDowell County.
And before we start, I want to make sure I've been informed that the respondents have an agreement that Mr. Williams will have 7 minutes and Mr. Hammock will have 3. Is that accurate?
That is correct, Your Honor.
Okay, thank you very much, and you have 10 minutes, and you can divide your time as you wish between opening and rebuttal.
Okay, 8 and 2 would work for me, Judge.
That'll be
Thanks.
great. I'll give you a warning.
I appreciate that. May it please the court, my name is Lonnie Simmons, and Rob Baster, Sam Petsong, and Bryn Pomponio. We represent the 7 coal miners who filed a products liability case in McDowell County. They are all separate cases, but they're joined for this appeal. It involves the same defendants and products that were discussed in the Hope decision issued by the state Supreme Court, where the court said the statute of limitations is a fact issue. And what happens is when this case was briefed below, the judge in the case issued a ruling in all 7 cases saying that if there was basically try to come up with some black and white rules that here as a matter of law the statute begins. And one would be if you filed for federal black lung benefits, and the other 2 are kind of related would be if you got more than a 5% award or otherwise a doctor found that you were impaired from dust inhalation disease. So those were really the holdings by the trial court, and I wanted to sort of highlight for the court why we respectfully believe that those rulings were incorrect. The controlling case, besides Hoke and Dunn, which our Supreme Court has repeatedly emphasized the factual nature of this analysis, but in a products liability case, Syllabus Point 1 of Hickman v. Grover, there are 3 things that you have to prove: that the plaintiff knew or by the exercise of reasonable diligence should have known, 1, that they were injured, 2, the identity of the maker of the product, and 3, that the product had a causal connection to the injury. So I wanted to look at the facts in this case and the judge's ruling just to illustrate why we believe the judge was wrong and how he misapplied. So the step 1 is the coal miner needs to find out, do I have an injury? And so one way they do that is they file for black lung. Okay, so you file for federal black lung. Simply by filing it doesn't mean you've got it. You think you've got it, but I know the briefs were fairly extensive, and we're trying to jumble 7 separate cases, but you can sort of see the pattern. You file like Mr. Hardy. He files for federal black lung in 2018. He's diagnosed with black lung in 2018. Then a couple other doctors say no, you don't have black lung. So it's an administrative process that is a very technical medical issue. And again, the coal miner's trying to find out, do I have this injury? And so all the coal miner can do is to rely on this system. And one of the most important points that we believe the trial court overlooked is the finding has to be communicated in some way to the miner. I think the judge below simply assumed if a doctor in some office writes down after looking at the x-ray, oh, this coal miner has PMF, that somehow the coal miner automatically knows that. And there needs to be evidence of that. And when the coal miners were deposed, I know there's a whole bunch of depositions in this case, very many of them testified the first time they even learned about it. So simply because a doctor on a particular date noted a PMF finding does not mean that the plaintiff involved knew about it. And so that's why we focus.
Did the claimants not have to have some basis for filing of the black lung claims? I mean, didn't there have to be some kind of evidence that they have that would at least tend to demonstrate that they had black lung?
Well, I think these cases demonstrate what a complex question that is. They think there might be something wrong, right? They're coal miners. They've worked in coal mines. They know OP exists, right? And so they do the right thing, the diligent thing. They apply for it. And when you go through it, like Mr. Dudleson, he files for black lung, and it's denied. Okay, and there's several examples in here where they had to apply several times. So if you're a coal miner and you apply for black lung and it's denied, are you somehow held to some standard? Well, gee, coal miner, even though it was determined you didn't have black lung, you should have reasonably and diligently searched the world to see if something else caused this. I mean, it just logically doesn't make sense. And that's why we believe the critical time period on the first part of the analysis is when the diagnosis is communicated to the plaintiff, and sometimes it's communicated, hey, I just got a black lung check. And in all 7 cases involved here, the civil suits, the products liability suits, were filed within the 2 years from each plaintiff knowing that. And so we think that's an important aspect that the judge failed to appreciate. He applied the Goodwin case, which is a per curiam case with a dissenting opinion. There's no new syllabus point. It didn't overrule Hoke or Dunn or Hickman. It didn't overrule these cases where there's actual syllabus points. And he acted as if some of the dicta in the case was the controlling law, and that's just simply not the law in West Virginia. That's just not the way it works. So we think that was one of the biggest legal errors that the judge committed, was basically focusing on the wrong standard and not applying the Hickman standard. The judge also made a finding that somehow when the underlying complaint in the Hoke case was filed in 2003, somehow every coal miner in the world is supposed to know, the Attorney General filed a claim against these products in 2003. Well, bet you're all on notice. Well, that's not the law anywhere. There was no support for that. To me, that's just another example of how I don't think this judge, who I think is a very good judge. I feel like I'm saying bad things about it. I don't mean to. He's a very good judge. He's very thorough, okay? But I just don't think he fully got the whole factual analysis that's required. The other aspect that I wanted to talk about, which is the first part is the discovery rule, and that's the knowledge of the plaintiff. So the focus is on, well, what did this plaintiff know, or with reasonable diligence should have known. So that's the first part. The other part, the fraudulent concealment part, which is talked about in Hoke and in Dunn, it focuses on the defendants, okay, and what the defendants did, okay, and to the extent that the defendants fraudulently concealed things about their products as they're selling them, and in the meanwhile, they've got internal memos, which we quoted in our brief. It's unconscionable that the user of this respirator has no way of knowing it's not working. Or another one that these respirators aren't fit for coal mines. Well, coal miners don't know that, and it only came out in the litigation that mostly started in Kentucky. I mean, that's the challenge with this kind of a case. It's a latent disease process, and they're not going to know it back then. So, and as a practical matter, on the fraudulent concealment, you're not really going to know until you met with a lawyer who knows it. That's when you're going to have actual knowledge of all this stuff that's going on.
On the fraudulent concealment, what evidence in the record was there of fraudulent concealment going on the dates where these statutes might have been running? I mean, I understand 80s, 90s, early 2000s. what was going on in the late teens in terms of fraudulent concealment as far as the record below?
As far as the record below, I mean, the way I look at the fraudulent concealment, I think the way courts analyze it, you have this affirmative evidence out there that they had ads. Oh, if you don't want to get black lung, wear the respirator. And we quoted some of that stuff in our brief. And the whole time, internally, they had this information. This is not fit for coal mines, and it was kept secret the whole time. We've only learned some of this stuff through the recent litigation, and a lot of it is under seal. And another fundamental error I think the judge made is he simply assumed that if you use a respirator and you got black lung, that respirator must have been defective, and that's why we made a point of citing to you. And I wanted to make sure I gave
You're
you.
at 8 minutes, so hurry.
I was
if you
gonna
wanna
get,
save time.
I just wanted to make sure I gave the court the site for two of their own experts who said simply, was asked that question. If you're a coal miner and you used a respirator and you got black lung, does that mean the respirator was defective? He said absolutely not. What the expert said is that means you must have gotten it when you didn't wear the mask. And all 7 of these plaintiffs acknowledged that they did not wear the respirator 100% of the time. So they could have gotten it during the times they didn't wear it. So I think I've hit everything I wanted to hit, and I'm out of time anyway. So we would really appreciate getting this reversed because there's a lot of facts that need to be addressed.
Thank you.
Thanks.
Mr. Williams, I'll let you know when you're about to run out of your 7 minutes.
Thank you, Your Honor. If I could get a 1-minute warning, that would be great.
That'll be fine.
May it please the court, Mark Williams for all the respondents with the exception of mine safety appliances, which Mr. Hammock will handle. I think it is telling that in discussing previous decisions from the Supreme Court of Appeals, the one that Mr. Simmons did not mention is the Collins case, which is the most recent writing on this question, which, as it turns out, deals with the exact same claims by a different plaintiff that went up on appeal after Judge Young in Wayne County against the same defendants dismissed that claim alleging a defective respirator for a underground coal miner because the statute of limitations had run.
Does it make any difference that that's technically unpublished?
It is a memorandum of opinion, Your Honor, so to that extent, it has less precedential value than a signed opinion, but it is still an indication of how our Supreme Court would deal with this. And it's important to the extent that the petitioners are taking the position that for whatever reason, the Hoke case is controlling. And let me just spend a moment talking about that. The State versus 3M case, which was the Hoke decision, a writ coming out of that case out of Lincoln County, in which I am counsel and several of us are on both sides are counsel, is a CCPA case alleging that the manufacturers of these respirators engaged in deceptive practices under the CCPA. To the extent that that decision says that statute of limitations questions are generally jury questions, parroting what Justice Ketchum said in Dunn and others have said in previous cases, that's true. But it was not a defining decision that said there is no way under any circumstances that summary judgment on a statute of limitations question can't be granted. In fact, most of the cases we're talking about here today were appeals to the Supreme Court of Appeals on a dismissal based on statute of limitations that were affirmed. And that is the Collins case, which was entered just slightly less than a year ago, albeit in a memorandum opinion, which I take to mean that the Supreme Court of Appeals saw that as settled law and a fairly simple case that did not require a signed opinion because there are no new developments of law. The Goodwin versus Bayer case was also an appeal of a dismissal of a case on statute of limitations grounds that was affirmed. Smith versus Raving Hawking, the same thing. And even Jones versus the trustees of Bethany College, which is cited by the petitioners, was a case where summary judgment based on statute of limitations was affirmed. So if you look at the Collins decision and the arguments that were made, they are essentially the same that are the ones made by the petitioners here. And While the petitioners seem to be taking the position now that the statute of limitations does not run until an administrative body would actually award co-workers pneumoconiosis benefits under either a state or federal administrative policy, Judge Cornish's decision in great detail enumerated how the statute actually begins to run from the point of the diagnosis. And in some cases, some of these individuals were diagnosed more than 2 decades before they filed this action. So as it is instructive to look at that opinion from Judge Cornish through the lens of what Collins says, because they are essentially on all fours together. And as for all 7 plaintiffs, what Judge Cornish found was that they knew they had a pulmonary disease that was related to coal mining. They knew it was related to coal dust exposure, and they knew what respirator they wore and why. So under those circumstances, it fulfills the 3 requirements that have been set out for products liability cases in West Virginia, specifically the Goodwin versus Bear case and Smith versus Raven Hocking.
Does it make any difference, the idea that on the one hand, you're dealing with CWP co-workers pneumoconiosis, and on the other, a progressive mass fibrosis, which at least my understanding is may not be due to exposure to coal dust, as opposed to silicosis, which may be mixed in the actual situation?
Well, it does not make a difference to the extent that this is a progressive disease, which we all acknowledge. So, for instance, it is not uncommon, in fact, Mr. Simmons noted that at various times during their work history, these individuals might be diagnosed with varying degrees of impairment, which will progress over time, because we know the co-workers pneumoconiosis is progressive. It is more of a progressive disease than a latent disease. A latent disease is more of one where there's an exposure, and then at some point in the future, it manifests itself through symptoms. Here, what we have, and it's replete throughout the record for all of these 7 plaintiffs, is they started having trouble earlier in their careers. They knew that there was dust associated with the mask, that they wore masks to protect themselves from dust. And then after that fact, it progressed and got more serious. Now, West Virginia has never recognized the 2 disease rule, which the plaintiffs have advocated for here, with the exception of in silicosis cases where the legislature adopted a 2 disease rule that was very limited in scope and which had a specific exclusion for co-workers pneumoconiosis claims. In fact, if you look at the decisions that have come down from the Supreme Court over the years, including the Smith versus Raven Hocking case and the Bethany College case, the worsening of an injury is not a basis to say that the statute of limitations does not begin to run. Because once you have an injury, once you know that you have been impaired in some way, that is the point at which it is the responsibility of the minor to investigate the claim and seek out whether or not there's a remedy. And in this case, all of these individuals in depositions, and the depositions are attached to the motions for summary judgment in the record, all of these individuals indicated that they knew they had co-worker pneumoconiosis, black lung. They either had family members that had it, so they were attuned to it before they even were diagnosed with it. They knew that. They wore the mask to protect themselves. In some cases, they said they found dust in the mask, which indicated to them a question as to whether or not the mask was actually protecting them. So under those circumstances, it's clear that Judge Cornish got it right. Now, on the question of fraudulent concealment that the Chief asked a question about, the important thing to note here is that there was nothing in the fraudulent concealment evidence that the plaintiffs seek to put into evidence that was directed at the plaintiffs themselves. All of them testified that the advertisements that they believe is evidence of fraudulent concealment, that they never saw those advertisements. In fact, those advertisements were directed at the distributors and the coal companies that purchased those respirators. So under those circumstances, with Judge Cornish making a specific finding that said that an appropriate motion for summary judgment had been made, and then that the burden shifts to the plaintiffs to show a reason why it should not be granted, and that they failed to do that, we believe that under those circumstances, all of those decisions from Judge Cornish should be affirmed. And I'll now turn it over to my colleague.
Thank you. Mr. Hammond, you got 3 minutes, and I'll warn you in a minute.
Good morning, and may it please the court. I'm Joshua Hammock on behalf of MSA. I'd like to use my limited time today to focus on maybe the simplest reason petitioners' arguments fail. As you've heard, the appeal hinges on when petitioners knew or should have known two things: that they were injured and of a possible causal link between their injury and our product. In Hickman v. Grover, the Supreme Court of Appeals acknowledged these details are, quote, often not known with legal certainty until after the jury returns its verdict, unquote. If legal certainty were required, the court noted, quote, we would have a situation where the statute of limitations would almost never accrue until after suit was filed. We cannot accept such a holding, unquote. Instead, the court has consistently held that for the injury, claims accrue when plaintiff has reason to believe something is wrong. That's Goodwin v. Bayer Court. For the causal link, the question is whether plaintiff had notice of a possible breach of the duty of care. That's McCoy v. Miller. Now consider petitioners' arguments. As to the injury, petitioners insist they had the requisite knowledge only when they were awarded federal black lung benefits. Only then, they say, was the factual question as to whether they were injured, quote, finally resolved, unquote. This argument alone would mean two petitioners' claims had not accrued when they filed their lawsuits. Edgel, Dudleson, and Gary Scott's applications for federal black lung benefits were not finally resolved at that time. We're off to a bad start. But things only get worse from there. As to the causal link, petitioners insist the critical date was when they met with Sam Petzonk. They say Mr. Petzonk told them that, quote, respondents allegedly designed and marketed a defective respirator, unquote. Elsewhere, they say he told them of a, quote, possible connection between their diseases and wearing respondents' defective respirators, unquote. Allegedly. Possible. As these two words confess, the supposed causal link has not been finally resolved, even today. If the cases go back down, MSA will present evidence that its respirators were not defective at all. And consider someone like Gary Scott, who wore an MSA respirator for less than a fifth of his 38-year mining career and wore no respirator at all 80% of the time. On a record like that, factual questions about causation abound. If they must be finally resolved for the clock to start running, we are years away.
1 minute.
Now. This finally resolved rule lands in the very paradox Hickman v. Grover sought to avoid 35 years ago. Petitioners are simply wrong about the law. The clock started when they should have known something was wrong, and Judge Cornish's comprehensive 45-page opinion examines that question in painstaking detail. Petitioners don't dispute any of the facts, and those undisputed facts lead to the inevitable conclusion that all the claims are time-barred. As such, we ask the court to affirm the order granting summary judgment. Thank you.
Mr. Simmons, you have a couple minutes to respond.
Thank you, Judge. In the briefs, we distinguished the various cases that have gone, but like the Collins case, another point that the court doesn't even address is this idea. It says he was diagnosed with PMF on a certain date. There's no evidence in the Collins opinion itself. Well, when was that communicated to the plaintiff? Because if the plaintiff is supposed to know or should have known through reasonable diligence something, there has to be evidence that they actually knew of the diagnosis. And all we're saying in all 7 of these cases, we're running it from the time that either that the agency made a determination or that they started receiving checks. They're still disputing it, right? He's right. Some of these employers, even after the award's made, they still dispute, oh, you don't have black lung. And that's why it's such a complicated issue for that prong one. Do you even have an injury to begin with? And that's why simply filing a claim in federal black lung can't possibly be the date.
Are you indicating that that particular issue of when they received the communication, assuming that they in fact did, has not been developed up to this point?
Oh, actually, in a lot of the depositions, the clients talked about, well, this is the first time I knew such and such, or when I got this is the first time I got a black. So yes, that was covered in the record. So that should be in there. Another good point from the products liability standpoint. There's a bunch of fact issues here. You didn't use it all the time. Maybe that's why should we be responsible for your injuries? Because you didn't use it all the time. Oh yeah, there's lots of fact issues here, but if you're throwing out on a summary judgment, you don't have a chance to develop those facts. And as far as on the fraudulent concealment, that the fact that it wasn't directed toward, well, the fraudulent concealment doesn't have to be directed specifically to a plaintiff. It's a discussion of internal records they have where they know from their own people these respirators were not fit for use in the coal mines. It didn't make a difference if it wasn't fit for Mr. Hardy or Mr. Dudleson. It wasn't fit for any coal miner, okay? And that's what they kept secret. And so it tolls until they find out about it. And we think both the discovery rule and the tolling rule protect these 7 clients, and we would respectfully ask the court to reverse the summary judgment motion so that all these fact issues can be developed.
Thank you for your arguments. I think we understand your positions, and the case will be submitted.
Thank you.
All right, standing while judges leave the bench.
Hello, good to see you.
Good to see you, Jess. Good to see you, Chief.
Just like the Fourth Circuit. All right. Mess out of here. Oh, Mark, good as always. Nice job.
Nice meeting you there.
Good to see you. Water bottle. Good job.
You ready? Call our next case, please.
Next on the Rule 19 docket, we have Jeffrey Darago v. Rodney Darago and Cathy Reeser, number 22 ICA 269, an appeal from the Circuit Court of Monroe County.
And Mr. Bryan, you may proceed. You have 10 minutes. You reserve whatever you feel appropriate for rebuttal.
If I may, let me reserve 2 minutes for rebuttal, please.
Yes, sir.
I'm John Bryan. I represent the petitioners in this case, and my client is the executor of the estate of Oscar Darago, who is the father of the parties. So at issue here is about $53,000 of proceeds that came out of federal eminent domain proceedings related to the Mountain Valley pipeline. So the decedent, during his lifetime, had entered into a contract with a law firm to represent him in those federal eminent domain proceedings. Prior to those proceedings being finalized and any proceeds being awarded to the decedent, he passed away. And they were finalized then by my client, the named executor in Oscar Darago's will. And that was around, I think, 2019. And then the $53,000 came in, was paid into the estate, and put it into an estate account. And the siblings had all discussed it at that time, you know, are we just going to split this 4 ways? And that was in accordance with the provisions of their father's will, which was, except for really 2 exceptions, any other funds were going to be split evenly between the children. So that while that was in process and that was that was put in the final report and recommendations for what to do with the estate assets. Then there was an objection after the fact by just one sibling, and that was a respondent, Rodney Darago, and he then asserted that he wanted all of the $53,000 just because it pertained to the real estate that he was left in the will. And so after the objection was filed, then we had the proceedings with the fiduciary commissioner, and that culminated in the report and recommendation by the fiduciary commissioner that indeed the pipeline fund should be divided evenly. So that then was objected to by the respondent, and we had a hearing before the county commission, and we don't really know the reason, but the county commission basically threw out the recommendations of the fiduciary commissioner and just said that the respondent should have that $53,000. And my understanding was basically that they just thought it was fair because it pertained to the land, therefore the landowner should get the money. They didn't really put any specifics in there about why they disagreed with the recommendations of the fiduciary commissioner. So then we appealed that to the circuit court, and the circuit court really ran away with an issue that I would argue wasn't even in dispute. So the circuit court basically says that, well, I think the important fact here is when title to the real estate was conveyed and when title to this pipeline easement was conveyed, and that controls the whole case. But the problem is that really wasn't even in dispute. The only dispute is $53,000 came in to the estate, not real estate. It was $53,000 from a law firm minus their fees and expenses. And, what does the testator's will express as far as what should happen to that money? That's really all that was at issue. And
the funds came in as a result of the burden on the real estate of the right-of-way, correct?
That's right. And I don't profess to be all that knowledgeable on federal eminent domain proceedings, and I don't know that the circuit court here was as well. I mean, the circuit court kind of went beyond the record and started looking into, the law of these federal eminent domain proceedings and whatnot. And I think that's just outside the record, outside of what was at issue. And if that's
a lot of things are outside the record here because there wasn't much of a record. So what happens in those situations when there's no record? Who bears the brunt of the faulty? I mean, when you read through the order, there's all kinds of things. Well, it appears maybe during an unspecified period, the dates aren't in the file. When there's a sparsity of information in the record by the time we get to the circuit court, who bears the brunt of that responsibility when what we have is off the record proceedings below?
Well, when I first saw the court's request that wanted some discussion on whether there's supposed to be de novo, proceedings at the circuit court, I think this court recognizes that the system that we use with the fiduciary commissioners and having a hearing before the county commission really is antiquated, and it just makes things more difficult. Really would have been great if this could have been handled de novo before the circuit court, because it's really not clear. I mean, my position is that we didn't make an issue of title to the easement. We didn't make an issue of title to the real estate. We just had funds come in, and our only issue is how it's to be divided. So our evidence, our presentation focused on, well, what was the intent of the testator? How does this money tie into what the testator wanted to do? It was the respondents who tried to make a technical issue about title to the easement. And in my understanding,
is it a technical issue if something's real estate at the time of the death when the will would take effect, and at some point later it gets changed? Is that really a technical issue?
My understanding, Your Honor, is that, our position is that these were proceeds, these are damages. These are money damages from eminent domain proceedings that were instituted during the lifetime of the testator. And my understanding is that the pipeline was already installed or in the process of being installed before the death of the testator. And I don't believe that was really an issue or developed in the record, but it wasn't like he died and then there was a settlement and then the pipeline was installed. Like, no, it was already, I believe, installed and done to my recollection before the money was ever paid. So these were just money damages.
The title of the real estate under West Virginia law would have passed at the time of death. So one question I have is, what authority was there for the estate to settle a right-of-way issue, an eminent domain issue on property that is no longer owned by the estate?
Again, I'm not I don't hold myself out as an expert on these federal eminent domain deals. So all I know is what was really in the paperwork back and forth with the law firm that was doing this. But it's my understanding that, they didn't have an option to say no to the pipeline being installed. It was already being installed. It was already in the works. The only issue is, what is the fair compensation for that?
But they reached a settlement. They could have litigated it and let a judge or jury decide it. They reached a settlement, correct?
Correct. The settlement was just as to the money damages to be awarded. So, they couldn't have said no to, like, oh, no, we're not going to agree, take the pipeline out. That wasn't an issue. There was no option not to agree.
There was an option not to settle, or they could have settled before the death.
Right. And Jeffrey Darago, or the respondent, when he was conveyed that property or devised that property, he took it subject to the encumbrances that were already there. So it was already encumbered by this pipeline. And his father had retained this law firm to pursue compensation for, the installation of the pipeline.
You've used 8 minutes. If you want to reserve some time for rebuttal.
I'll reserve my final time. Thank you.
Thank you.
May it please the court, I'm Jeff Pritt here on behalf of the respondent, Jeffrey Darago. As I understood the court's notice of oral argument today, you wanted us to focus exclusively on whether or not West Virginia Code 41-5-7 required a trial de novo before the circuit court on these issues involving estate administration. And I guess I have 2 things to respond to that specific issue. Number one, I certainly believe and agree that West Virginia Code 41-5-7 does require a trial de novo at the circuit court level on those issues which it controls. But number 2, it has no application to this particular case. Just so we're clear on what transpired here, this was the exceptions that we filed that started this whole case revolved around the fiduciary's report, basically her proposed final settlement of the estate of Oscar Darago. And once she filed that, she advised the parties, sent them proposed copies of it so that they could review it and file exceptions. My client retained me to file exceptions to it. And when we did that, the county commission referred it back to the fiduciary commissioner or asked her to conduct a hearing on it. At that time, COVID was still raging pretty heavily, and we ended up agreeing to just submit briefs on it rather than have an actual physical hearing due to the COVID situation. So the fiduciary commissioner considered my exceptions. Mr. Bryan filed a response on behalf of his client. I filed a reply. And I guess we did not include those in the petitioner's appendix. And I apologize to the court for not advising Mr. Bryan to include those matters. I think also we didn't really set forth what statute the appeals were really based upon. But the facts here were essentially undisputed. And I don't really think there's anything in the briefs that's really necessarily disputed factually. And the bottom line, I think, is that when we look at the applicable statutes here, and I've kind of had a little change of heart myself as to which one I thought applied this morning, but I think the statute that covers this type of appeal situation is West Virginia Code 44-4-17, which is about the examination and correction or recommittal of the report of the fiduciary commissioner. And basically, as I understand it, when we filed our exceptions, the county commission referred it back or recommitted it to the fiduciary commissioner as appropriate under that particular statute. And under that statute, the fiduciary commissioner can conduct a hearing, which she did, which again we held via briefing rather than an in-person hearing. She prepared her revised report, ruled against my client, and directed that the 3 family members would share the easement proceeds. And then we accepted to that. And under the statute, it specifically says that if there's a further exception, well, not a further exception, if there's exceptions to the report, the county commission shall hear no new evidence, neither it nor the circuit court on appeal. And it's really just about as clear as could be. And I think that that's the statute which controls this case, in which basically left both the county commission and the circuit court with no options, although the county commission did have that initial option to recommit it to the fiduciary commissioner to take some additional evidence and conduct a hearing on this particular issue, which it did. So the circuit court was limited to just the record below on this appeal that Mr. Bryan filed on behalf of the estate. And essentially that record, while somewhat limited, again, I think it's relatively clear cut as to what happened here. And also I would just refer the court to the Haynes versus Kimball case, 221 West Virginia 266, 654 Southeast 2nd 588, a per curiam decision from 2007, note 8 of that opinion, certainly dicta, but I think the court, the Supreme Court, went into some detail there to note that in most instances regarding appeals to the circuit court level from the county commission on an estate matter, that other than West Virginia Code 41-5-7, most of the other appeals are basically going to just be heard on the record that was made originally before the fiduciary commissioner. And I'll back up a moment. The West Virginia Code 41-5-7, just so we're clear too, I think that statute applies only to decisions admitting or refusing to admit a will to probate, and that was not our situation here. There was never this will was never contested, completely uncontested. It was admitted to probate without incident. So our position here is that the circuit court properly reviewed this case, basically sitting as an intermediate court of appeals, and considered the record that it had, and it rendered the decision based upon the record that was before it. It really had no discretion to do anything further under West Virginia Code 44-4-17. And from our standpoint, of course, we very much agree with the decision of the county commission to reverse the fiduciary commissioner, and with the circuit court to affirm that decision. Our client...
Why couldn't the circuit court have remanded it back to the county commission and said there's just not enough facts in here to make a reasonable determination, and if the county commission needed to, could remand it back to the fiduciary to do the same? Why couldn't that have happened here?
That is a good question, and I don't know that the circuit court, I would presume the circuit court had jurisdiction to remand. I think that's generally within its purview. Even though the statute in question 44-4-17 does not really, it does give the power to the county commission to recommit the report to the fiduciary commissioner, and doesn't really say anything. It does say circuit court and the county commission shall hear no new evidence. It doesn't really say anything about remanding by the circuit court, but nevertheless, I mean, I would note that the circuit court did have the benefit of the pleadings that we filed before the county commission with respect to our initial exceptions and their response and my subsequent reply to that, that essentially was what the fiduciary commissioner heard the case upon, since we did it by briefs only. And again, I guess we did not get those into the record here for this appeal, as I recall.
Counsel, the order from the court obviously had a lot of cautionary language or arguably limiting language in terms of the evidence it had in front of him. But then it went on and made the decision, and at least my impression is, looked at two key dates: the date of death, and as under West Virginia law, date of the conveyance of the property, and then the date that the settlement agreement was finally reached, which was in March of 19, so 4 months later. First question I have, and first, is that accurate?
Yes.
And second, assuming the property transferred on the date of death, the real estate, did the executor have the authority to settle the condemnation action?
I really don't think so, personally, but they did, so.
And your client accepted that settlement?
Well, my client did not sign off on the deed, and when it was proposed that the funds be split 3 ways, we accepted to that. So I guess the answer is sort of no. I mean, he understands. I think reluctantly our position is they're going to get the right-of-way through there regardless.
But your client hasn't challenged that settlement?
He has not challenged the deed or anything like that, no, that is correct. Just the distribution of the monies, because I think when you get down to the base level of our argument, it's that this was a specific legacy to him, that he received the farm in Monroe County, his sister received some Ohio real estate, and the brother that's handling the estate, if I recall correctly, got the biggest share of like some money market funds. So
how do you respond to counsel's argument that at the time of death, and in essence the conveyance of the property at that time, that the property was already, even though there hadn't been a settlement, that it was already encumbered at that time, so that all he received was the property subject to the encumbrance?
that's interesting. I mean, it's not in the record, number one, and I'm not certain exactly when the easement was constructed. I know the contingency fee contract with the law firm noted that if the case might end up being dismissed, I don't know if they would have received any proceeds. I mean, the Mountain Valley Pipeline is what this one was, and of course it's been fought very actively for many years. Looked like it was on the ropes several times, but has always managed to survive, and I guess is actually going to go through at this point thanks to Congress. So, at the way I look at it again, I think what Judge Irons focused upon, which I thought was a good analysis on his behalf, was the West Virginia statute that indicated title doesn't really pass until the monies are paid and received. And that definitely did not happen until after Oscar Darago's passing. So there'd been no passing of title to any third party until after Oscar Darago had expired, which I think goes back to kind of the questions you'd raised with Mr. Bryan, that at the time Mr. Darago passed, I mean, there was really, there was nothing encumbering the property legally anyhow at that point as far as in the records of Monroe County. But
I think you've used most of your time. If there's no further questions.
To the extent, and the chief asked you about it, assuming that there was authority of the circuit court to remand if it felt it did not have any adequate information, can you identify any facts or any arguments about facts that needed to be developed?
I probably was not as clear as I could be on that. I really don't know of any facts that would really, in my opinion, change the basic analysis here. I mean, to me, I tend to focus on the date of death, what was the status of the property title at that time, and the fact that the land was not formally sold and paid for until 4 months after death.
Where is that in the record? Because in the order it says he doesn't know. He says it appears that it happened after. I mean, that's the language of the order. It appears, and he says I don't really know when the date of the settlement was. So where from the record do we get this determination that it was 4 months after the death?
It's definitely recited in the facts sections of our brief. I don't know if there's an independent document that confirms that. I don't think there's any disagreement as to the fact that it settled after death. Of course, Mr. Bryan's acknowledged that this morning.
Doesn't the court indicate it doesn't know a particular date that the settlement was reached, but cites the actual execution of the documents,
Yes,
which was in March of 2019.
right.
And consistent with the argument that that right-of-way technically isn't conveyed until you've got a signed agreement and the transfer of money.
Correct.
I mean, subject to the argument that counsel made.
Right. Yes, no, that's exactly right. All right, well, thank you all very
Thank you.
much.
You have a couple of minutes, Mr. Bryan.
Your Honors, one fact that, in hindsight, that could be developed here, that should be developed here if this is the discussion, is, well, when specifically did the pipeline installation begin? And what process was it when Oscar Darago died? I don't even know the answer to that because I don't know that even was developed below. Secondly, as far as the $53,000 goes, what was the basis for that award as far as what was negotiated? And the court pointed out the court didn't know. I mean, was this for like inconvenience partially for Oscar Darago having to put up with the construction on his property? I don't know. So should it even run with the property? It may have been for damages such as inconvenience that the testator suffered, while he was still alive. And so that definitely could be developed if that's the central issue here. But again, from the beginning, we saw it as, all right, we have $53,000 here that, as the fiduciary commissioner correctly concluded, had the testator been alive, what would have happened with that money? He would have put it into his checking account, and then it would have fell within the residuary clause of the will and been divided evenly between his children.
Isn't that intention purely speculative?
I wouldn't say so, because as the respondent pointed out in their brief, that the law looks at the moment of death as we presume that he wrote his will as of the moment of his death, and so we know that he knew that this litigation was going and that there was anticipated proceeds coming, and he didn't provide that those go specifically anywhere except for within his residuary clause. Lastly, this reminds me of something I'm currently dealing with in a Greenbrier County case where another client of mine purchased some farmland on this same Mountain Valley pipeline. And so he bought this property, but the guy before him had taken money from the pipeline to sell them use of a staging area, where they store some of their equipment, they store, all the pipes before they install them. And he's had a heck of a time dealing with these people, with them cutting his fences, putting locks on and crushing some of the drainage apparatus in his field. And this guy got no compensation for it. It was the prior owner that got all the compensation that the new owner, my client, is now suffering for.
That compensation was paid before the conveyance of the property, correct?
I don't know when it was paid, but it predated. It was an encumbrance that he was on, at least constructive notice that he was getting, and I would say it was the same thing here. The respondent, at the very least, had constructive notice that this property was encumbered by this pipeline, and any funds were a contractual negotiation between the decedent while he was still alive and his lawyers. Thank you.
Thank you. I think we understand your positions. The case will be submitted. Thank you very much.
Please rise, remain standing until the judge's meeting room. Court now adjourned until 10 a.m. tomorrow.